Welcome. Welcome, bienvenidos. My name is Patricia Ferreira, and I serve as the current chair of the AERA Bilingual Education Research SIG webinar working group. We are so glad that you could join us today for our webinar titled Leveling Up, Amplifying Advocacy for Multilingual Students. We are honored to be in community with you all. Before we begin, I'd like to remind us of ground rules for participation and engagement. We encourage respectful and supportive engagement in the chat. We encourage active listening, honoring the speaker's perspectives, and using inclusive language. To start building our community, please take a moment to share in the chat where you're joining us from today. We'd love to see the range of languages, regions, and places represented among us. This webinar is co-sponsored by the Center for Applied Linguistics, the National Association for Bilingual Education, and the AERA Bilingual Education Research Special Interest Group. We would like to acknowledge the leadership of Dr. Diep Nguyen from Cal and Dr. Josie Tinajero from NABE, who are instrumental in the ideation and organization of this webinar. We also extend our sincere gratitude to Dr. Garcia from AERA for her unwavering support. This afternoon, we gather to join a timely conversation about multilingual learners' rights, educational access, and advocacy in the current policy context. Specifically, this webinar will examine current efforts to reverse Plyler veto and offer updates on the most current state and national initiatives aimed at protecting Plyler and ensuring educational access to all students. We also aim to continue building community by holding conversations that can drive public engagement, influence policy, and support community-centered change. This summer, the webinar working group members are Elizabeth Yorca, Emi Tomita, Jima, Nicole Misra, Angeles Muñoz, and myself, Patricia Ferreira. Thank you, team, for your contributions. We are being hosted by the Center for Applied Linguistics. Thank you, Christy Hang and Althea Rowe, for your technical and logistical support. And here's our agenda. We will hear opening remarks from the webinar co-sponsors. Then we will listen to presentations from 2 keynote speakers and 3 panelists. Following that, there will be a Q&A session, and we encourage you to please type your questions directly related to what the keynote speakers and panelists share in the Q&A. After that, we will share our call to action and resources to engage in advocacy work. We will now move on to opening remarks from leaders from the webinar co-sponsors, Dr. Suzanne García, Dr. Margarita Machado Casas, and Dr. Diep Nguyen. Dr. Suzanne García is an associate professor in the Department of Education and Leadership and the director of the Monterey Institute for English Learners at California State University in Monterey Bay. She serves as the AERA Bilingual Education Research SIG Chair for 2026-2027. Dr. Garcia, please.
Gracias, Patricia. Bienvenidas, bienvenidos, bienvenidas to everyone joining us here today, and muchísimas gracias to the webinar organizers. As the chair of the AERA Bilingual Education Research SIG, the schooling experiences of racialized and multilingual children are not only the heart of the scholarship that many of us write about, but this specific demographic, undocumented students, are children and bilingual teachers we have worked with as bilingual teacher educators. Raising awareness about how community members can take action is timely and urgent. I would argue that this work never stops, no matter who is in power. I also encourage folks to explore ways to take action in ways that are within your capacity. Even the simplest act helps, like donating to an organization that supports undocumented students and their families, writing an opinion editorial, sharing resources with your local community that support undocumented people, or simply just being a listening ear to those that need it right now. Thank you, and I hope you all enjoy the webinar and the messages that the panelists are sharing here today with us.
Thank you, Dr. Garcia. Next, we'll hear from Dr. Margarita Machado Casas. Dr. Margarita Machado Casas, NABE President and Western Region Representative, is a full professor at San Diego State University and an internationally recognized scholar in bilingual, multicultural, and transnational education. Born in Bluefields, Nicaragua, she has authored more than 80 publications and leads initiatives advancing educational access, advocacy, and opportunity for multilingual learners. Welcome, Dr. Machado Casas.
Buenas tardes, good afternoon. On behalf of the National Association for Bilingual Education, NABE, I would like to welcome, it's really an honor to welcome you to today's important conversation, Leveling Up and Amplifying Advocacy for Multilingual Students. First, I want to thank and sincerely thank AERA Bilingual Education SIG for hosting this timely webinar and creating this space for research, practice, and advocacy for us to come together as a community. And I also want to thank the Center for Applied Linguistics for co-sponsoring today's event. This collaboration is critical because we're stronger together, especially during these times. We have to work together. I also want to thank our keynote speakers, the panelists, the organizers, and everybody who's joining us today. Your presence reflects the strength of our field and our collective commitment to our multilingual and non-bilingual students and our families. This conversation could not be more timely. At the center of today's discussion of Plyler versus Doe is this landmark 1982 Supreme Court decision affirming that children cannot be denied access to public education based on their immigration status. For more than 4 decades, Plyler has provided essential protections for our students, for our children, our community. And today that protection is being challenged, and that is simply unacceptable. And I want to share with all of you that this issue in particular is very, very personal to me. I lived in the United States as an undocumented immigrant for 17 years. I know what it means to live under the uncertainty, to wonder whether you're going to be able to pursue an education and build a future because you don't have an immigration status. So when we talk about Plyler versus Doe, we're not only talking about a legal principle, but for many of us, this is very, very, very personal. These are our students, these are our families, these are our communities. And for some of us, these are our own stories. And I want to just plainly say that today it's really critical that we all stand together and we say this is unacceptable. For us as a field in bilingual, multilingual education, this is deeply consequential. Bilingual education has always been grounded in educational equity, linguistic rights, inclusion, and the belief that our students and our languages and our cultures are assets, not barriers. When educational access is threatened, our field has this responsibility to respond. And this is why I think it's so critical that we're here today. That's why I encourage every one of you today to turn what you learned today into action. And at NABE, we host monthly advocacy days, bringing educators, researchers, families, and advocates together to stay informed and to make our voices be heard. So I invite you to take what you learned today to make our collective voice stronger, to make our collective knowledge stronger, and collectively to take action to make a difference for every one of the students and families that are feeling the consequences of what's happening today. Thank you again to every one of you. Thank you again to the Center for Applied Linguistics. And I look forward to today's conversation and most importantly, to take action that comes from it. Thank you.
Thank you, Dr. Machado Casas. Next, we'll hear from Dr. Diep Nguyen, who serves as President and Chief Executive Officer of the Center for Applied Linguistics. Welcome, Dr. Nguyen.
Thank you, Dr. Ferreira. I am very, very honored to be here to represent the Center for Applied Linguistics and as a co-sponsor for this very exciting gathering of minds and hearts. I don't think I have to say much about CAL because CAL has its history since 1959, and I hope that in your career you have touched and been touched by the work at CAL. As a new president, not only in 2 years, I want to tell you that in our core mission, we work to protect student language rights and equal access to education. And we work at the intersection of policy, practice, and research. And we are very honored to be here with you to explore the possibilities of advocating for our students within these spaces. In this webinar, you will hear from leaders on the front line, your researcher colleagues and others who have stepped up to lead, who had worked alongside of other collaborators to advocate for our beloved students and their families. I hope that you will go away feeling validated on your own effort, inspired to take up your own place in this struggle. So wherever you are, each one of us has a role to play, whether we are leading or we are supporting and being ally, joining as collaborator, but I hope that you go away not being a bystander. I want to particularly express my gratitude to Dr. Josefina Tinajero and Dr. Patricia Vereda from Western Washington U, who have acted as thought partners and collaborators in organizing this webinar. Thank you for being here. Thank you for engaging in this very important and timely conversation. And I hope to hear more from what you have to say and have the conversation together. Thank you.
Thank you to our co-sponsors for your valuable remarks. Now we will transition into our keynote speaker presentations.
So our keynote speakers are two professionals committed to educational equity and opportunities for Latino, immigrant, bilingual, and multilingual communities. Mr. Thomas Saenz approaches this work primarily through civil rights law, and Dr. Maria Cody through education research, teacher preparation, and advocacy. We will hear from Mr. Saenz first. Thomas Saenz is a president and general counsel of MALDEF, where he leads litigation, policy, advocacy, and community education to promote the civil rights of Latinos in the United States. Saenz practiced civil rights litigation at MALDEF for 12 years and served as a lead counsel in numerous cases, including challenges to California Proposition 187, California Proposition 227, local restrictions on days laborers, free speech rights, and California 2001 congressional redistricting. Saenz rejoined MALDEF in August 2009, and in 2016, Saenz argued before the Supreme Court in United States versus Texas, representing interventions defending Obama administration deferred action initiatives, and Saenz graduated summa cum laude from Yale College in 1987 and received his law degree from Yale Law School in 1991. He has taught civil rights at several law schools and has been published numerous times. We are honored to have Mr. Saenz share his perspective on the broader political context surrounding the law, Plyler's place in the history of bilingual education, and the current legislative and administrative efforts to limit Plyler, as well as responses to these efforts. Thank you.
Thank you. And I'm happy to join you this afternoon, and I'm very pleased that there are so many of you joining for this critical discussion of Plyler versus Doe. For anyone who is not familiar with MALDEF, we are a now 58-year-old national legal civil rights organization founded in 1968 in San Antonio, Texas, but our headquarters currently and for the last several decades has been in Los Angeles, California, from where I am pleased to join you this afternoon. Over MALDEF's 58-year history, perhaps our most well-known and most cherished case is Plyler versus Doe. From that vantage point, you can understand that MALDEF sees Plyler versus Doe in a somewhat proprietary way. And ever since the decision was issued 44 years ago, we have worked very carefully and assiduously to ensure that Plyler's principles are followed everywhere and to prevent any violations of Plyler versus Doe. As you all know or have heard, Plyler versus Doe is a 1982 Supreme Court decision, a 5-4 decision, in which the court held that the Equal Protection Clause of the 14th Amendment guarantees every child a free, public school education from kindergarten through 12th grade, regardless of immigration status. The case began in the late 1970s when MALDEF filed Plyler versus Doe in Texas. It challenged a Texas state law enacted in the mid-1970s that permitted local school districts to either deny the enrollment of undocumented students or charge tuition to undocumented students who seek to enroll. So MALDEF filed a Plyler versus Doe challenge. It was later joined by a subsequently filed case by other lawyers, and the two cases moved up to the Supreme Court together. Now, the 1982 decision, as I indicated, was 5-4. I should start, however, by pointing out that when the case was filed, MALDEF had no strong expectations that they would win. The case was viewed by lawyers as a long shot, and my predecessor, the then president of MALDEF, Vilma Martinez, recalled recently in an interview on our website that it was a long shot, but she genuinely believed the law needed to be challenged, even if ultimately that challenge were to fail. Of course, it did not fail, and we achieved that 1982 decision. Important to note that it was a split decision 5-4, but every single one of the justices joined an opinion, either the majority or the dissent, that stated that they viewed the policy itself as folly. Terrible public policy. The only difference of opinion between the majority justices and the dissent was about the constitutionality of Plyler versus Doe. Now, given that Plyler is such an important case in MALDEF's history, as I said, we continue to monitor on a regular basis developments in relation to the law to ensure that it is complied with everywhere around the country. Now, based on those ongoing efforts, I want to begin by saying the following. There is no imminent danger that Plyler will be overturned. Now, that is not to say that there are not constant attacks. There are. And it's not to say that those attacks on Plyler have not increased in recent months and years. Both of those things are true. But for reasons that I will explain, Plyler itself is in no imminent danger of being overturned by the current Supreme Court. Now, historically, it's important to note that the attacks on Plyler began almost immediately after the decision was rendered. Right-wing extremists who are against immigration seized upon the decision as something that they would challenge on an ongoing basis. Indeed, there have been only two. Historically, in 44 years since Plyler was decided, there have been only two states that have actually enacted laws that violated Plyler. So it's important to note that even though it's been under constant attack for 44 years, only two times has a state acted to put in place a law that violates Plyler. The first such challenge was a direct challenge to Plyler. It was in Proposition 187 in California, enacted in 1994. So important to note that was not enacted by a legislature. It was enacted through the public initiative process in California. It was part of the infamous Proposition 187. Section 7 of that law directly violated Plyler. It stated that any child reasonably suspected of being undocumented could not be enrolled in public school. The proponents of Proposition 187 acknowledged that Section 7 would violate Plyler versus Doe, but they argued that they put it there specifically for that reason, to tee up a revisiting by the U.S. Supreme Court of the Plyler decision in the hopes and expectation that a subsequent court would not split 5-4 in favor of the constitutional right to attend school, but would split against the constitutional right to attend school and allow states to restrict undocumented students' enrollment in public education. Now, for reasons I'll explain, it has become much more difficult to wage such a challenge. But it is important to note that that first state law that directly violated Plyler was immediately enjoined in federal court and in state court because of Plyler. And ultimately, that provision, and indeed the bulk of Proposition 187, was struck down as unconstitutional, but not on the basis of equal protection. And that's a critical distinction. And I'll get to that after I cite the second state that has directly violated Plyler, and that was the state of Alabama in 2012, when the state enacted an anti-immigrant omnibus bill following Arizona's SB 1070 the prior year, but enacted a law, and I should have said 2011, not 2012, but enacted a law that included a provision requiring public schools to collect the status of not only every student, but every parent enrolling a child in public school. Well, unlike Proposition 187 and the Texas law challenged in Plyler, that did not directly prohibit enrollment. You can understand that collecting data would have the exact same effect of deterring enrollment of undocumented students, and indeed deterring enrollment of U.S. citizen children of undocumented parents. But that law in Alabama was also, like Proposition 187, struck down almost immediately. And it, like Proposition 187, ultimately relied on preemption, or the supremacy clause of the U.S. Constitution, to strike down these Plyler violating state laws. The supremacy clause guarantees that federal law is supreme over state law, and in the realm of immigration regulation, federal law is supreme because the Constitution assigns regulation of immigration to the United States government, not to states. So in both cases, the courts concluded that federal law preempted means prevented the states of California and Alabama from enacting laws like the ones they did that violated Plyler. Now, it's important to note here that what had happened in the interim was that in 1996, after it enacted the Welfare Reform Act, and that title, the title within the Welfare Reform Act addressing immigrant eligibility for public benefits, the Congress subsequently enacted a provision that specifically codifies Plyler into federal law. That is to say, they enacted a law that effectively said, in regulating eligibility of immigrants for public benefits in the states, we do not mean in any way to disturb or change the holding in Plyler versus Doe. And it cites the decision directly in federal statute. Now, what's critically important about that is that any new law that violates Plyler versus Doe would not be challenged under the Equal Protection Clause as the original case involved. Instead, they would be challenged as preempted by federal law that specifically states Plyler is the law of the land according to the Congress and the President through that law enacted in 1996. Now, why that's important is that so many of those who challenge Plyler rhetorically these days assert that they want to revisit the holding of the Supreme Court in Plyler versus Doe, but none of them seem to understand, including the Heritage Foundation, including Governor Greg Abbott, who kicked off the most recent round of discussions of challenging Plyler, but including all of the others in leadership positions in this country who have called for violating Plyler in order to tee up a revisiting of the equal protection decision by the Supreme Court in 1982. Problem is they never get there, because any Plyler violating state law would be challenged first as preempted under that state statute enacted in 1996. And when the case is resolved on that basis, you never get to ask the Supreme Court to revisit and change its 1982 decision about the Equal Protection Clause of the 14th Amendment and its protection of the right to education for children regardless of immigration status. That's why I tell you that Plyler is not in imminent danger. All of the threats, all of the rhetoric are really about dog whistle politics to the base that these leaders see as supporting them and their party. They should understand, and if they don't, they simply don't understand the law, that there is no opportunity to revisit the Plyler decision in the Supreme Court simply by enacting a Plyler violating statute. I want to end by adding one more thing. Another reason you have never seen a Plyler violating statute actually enacted, other than those two exceptions, California in 1994, Alabama in 2011, is because when they really look at the issue, no one actually wants to implement violations of Plyler. And here's why. What would you see if a Plyler violating state law were actually implemented? The first thing you would see is lots and lots of children out of school and on street corners and in neighborhoods around that state. I guarantee you the folks who are threatening to violate Plyler and enact statutes to keep these children out of school, their constituents will be the first to complain about why are all those brown kids hanging out on street corners in my neighborhood. So they don't want that from a political standpoint. But longer term, anyone who supports public education understands that ultimately violating Plyler is a threat to public education wherever such a Plyler violating statute is enacted. Why? Because you exclude any group of kids from school and other kids will follow them. So the first kids who will follow the kids who are prevented from enrolling because they're undocumented are their younger siblings. You all know that there are mixed status families where older children may be undocumented, but younger children are citizens. So those younger children will follow their older siblings out of school. And then the friends of both the older siblings and the younger siblings will choose also to leave school because why should I be in school when my friend doesn't have to be here? So ultimately, this undermines the public education system by pulling a high proportion of kids out of school. And by the way, enforcing truancy laws would be impossible because any child who knows what they're doing will say to a truancy officer, well, I don't have to be in school because I'm undocumented. And that truancy officer has no way of verifying that that child is not undocumented. So,
Mr. Saenz, I'm sorry to interrupt. We need to move forward with the next speaker.
I'm about to finish.
Thank you.
Long term, Plyler violating statutes are a threat to public education writ large. Thank you.
Okay, now y'all can hear me. Thank you, Mr. Saenz. We will now hear from Dr. Maria Cody. Dr. Cody is the Goodnight Distinguished Professor in Education at North Carolina State University and a professor of multilingual education. Her work focuses on multilingual learners, rural communities, and the preparation of educators who work with multilingual learners. Dr. Cody received her Doctor of Philosophy degree from the University of Colorado Boulder using a lens of critical place consciousness education, systemic equality, and equity. Dr. Cody examines multilingualism, bilingualism, rural education, bilingual education, teacher and leader education, and language policies. Her forthcoming book is Spaces of Hope for Rural Multilingual Learners in 4 Educational Movements. It's a privilege to welcome Dr. Cody to examine Plyler's original legal rationale for the ruling and the former General Attorney's remarks regarding the case in relation to language rights. She will also discuss how Plyler's benefits multilingual learners, how it relates to education and literacy development, and why access to education is so important for multilingual learners and their families. Finally, she will reflect on the role of researchers as both scientists and advocates.
Thank you very much, and thank you for having me tonight. Thank you to Mr. Sayans for framing the Plyler versus Doe case. In my brief remarks this afternoon, I'd just like to frame the case at a different level so that we in the room here across the country and indeed around the world have a sense of what advocacy could look like and how that could play out in our communities. So if you could please go to the next slide. In my brief remarks, I'd just like to note, and you could please click again here, that education is something that is not accessible in the primary grades or elementary grades for all children across the world. In fact, if you could click again, please. According to the United Nations, UNESCO, there are 79 million children of the primary school age or elementary school children who have no meaningful access to education. I'd like to come back to the word access in just a minute. And 272 million children across all educational levels don't have access to schooling. Next click, please. In 1960, the United States participated in the Convention Against Discrimination in Education. This was a convention that was held in Paris, France, and it was held by the United Nations organization. The convention established several key principles of education that I believe are relevant to the Plyler versus Doe case today. And they're principles that we should keep in mind as we're in our local communities thinking about how we can advocate for children who are undocumented in our local schools and communities. The first real reference is Article 4E, that the convention stated that primary education is free and compulsory and should remain so for all children. And the next click, please. The next Article 4E relates to give foreign nationals resident within their territory the same access to education as they would have given to their own nationals. That is particularly true in the case of Plyler. And I want to note here in these remarks that the United States signed the 1960 convention document, but never ratified it, and indeed was the only country not to ratify the convention in 1960, the convention documents. So this is an important point, and it begs two essential questions. The first is we must ask ourselves, what educational and human values do we hold as a people? A fundamental question. And the second question is, can a state, in our case, a country, condition a child's access to basic education on their immigration status? So next slide, please. I'd like to present here a 4A framework by Katerina Tomaszewski in 2001, who works for the United Nations. These 4As really are some way for us to think about advocacy in local communities and spaces. The first is that schools need to be available for children, and that is schools have to be available, teachers, the infrastructure, and educational opportunities must exist within those spaces. Next click. In the second one, the second A is accessibility. And here, people must be able to access education without discrimination or prohibitive economic, geographic, or other barriers. And in our case, we need to say political or immigration barriers that would curtail access to education for children. In the third A, education must be acceptable. It must be appropriate. It must be high quality. It must have safety, and it must respect human rights. And finally, in the last, education must respond to learners' different circumstances and needs. And in this regard, education needs to be adaptable. Next slide, please. So with respect to the Plyler versus Doe case, first click, please. The case was very important. And as Mr. Sayans pointed out, the different justices came to a similar conclusion, but five wrote for the majority opinion and 4 wrote for the minority opinion. And that was largely based on their positionality and their position regarding the constitutionality in the 14th Amendment. But I'd just like to briefly go through what some of those arguments were in those cases. And the reason is that these are similar arguments that were not only valid in the 1981 conversation, but the 1982 decision. They're as valid today as they were back then. The first one is that children are persons entitled to equal protection, in particular under the 14th Amendment. And this statement was made by Justice Marshall, that education is closely connected to fundamental constitutional values in the United States. The second was Justice Powell, who noted that children should not suffer a lifelong educational penalty because of their parents' immigration status. And we see this by noting that children should not bear responsibility for their parents' immigration decision. And that is definitely the case regarding immigration status today. The third was Justice Blackmun, who noted that education has an exceptional social importance. And Mr. Science pointed this out, that in fact, our society, everyone in society benefits from all children having access to education at the primary level and indeed in the K-12 and the K-12 sphere of education. And finally, Justice Berger, who wrote the minority opinion, in fact, noted that it is senseless for an enlightened society to deprive any child of elementary or primary level education. So before you go into the next slide, I'd just like to say that I think it's important to go back to some of the language in the Plyler case and some of the conversations and discussion that the justices had with the attorneys arguing the case. And to hear their voices from 1981 is very powerful as we talk about the 1982 decision that they eventually wrote. So the next slide, please. In this last slide, second to last slide, I'd just like to share Justice Day O'Connor and a little bit of her voice. This is a piece from the case. And you see along here, this is a transcription of the case when she asked Attorney Hardy his opinion about the undocumented status of children. And please note that the language here, illegal alien, is the language that was common language when the case was discussed in 1981. So please click.
Before you sit down, please, how do you compare the children of the undocumented or illegal alien with the illegitimate children that the court considered in Lally? The children themselves have a status over which they have no control, the children of these illegal aliens. Does the Texas statute then punish these children for something over which they have absolutely no control?
Okay, I'm going to ask you to go to the next slide. Thank you. And that's going to be available for you to hear the rest of the audio, but in the interest of time, if you could go to the final slide, please. I'd just like to finish up by saying that we're here to level up, and we're here to level up on the Plyler v. Doe case. In the event that it shows up in our local communities, that it's challenged in the courts and in the state at the state level. And I'd like to note, next click please, that all 9 justices were actually much closer on the opinion than they were on the vote. Next click please. And similar arguments about what is jurisdiction and the legal status of undocumented children may be brought up to challenge Plyler. And finally, last click, as we level up, I'd like for you to please consider what educational and human values do we hold as a people? And you can please click. And can a state actually condition a child's education to and access to basic education based on their immigration status? So with those brief remarks, I'd like to turn it over to the next speaker. Thank you.
Thank you, Dr. Cody. Thank you both of our keynote speakers for your insightful presentations. Together, you've provided valuable historical, legal, and policy perspectives that help frame today's discussions and underscore the importance of Plyler versus Doe. We appreciate your expertise and the context you've shared with us. We'll now transition to our panel discussion, where we'll hear from the advocates working on the ground about how these issues are playing out in their states, the challenges they are facing, and the strategies they are using to respond. After the panel, we'll reserve time for audience questions, so please continue submitting your questions through the Q&A. So now we'll transition into our panelist presentations. We'll hear from Dr. Kate Mencken, Dr. Trish Morita Mullaney, and Dr. Julie Sugarman, 3 distinguished scholars whose work examines how the U.S. educational system serves multilingual learners, and with whether educational policies and practices genuinely support linguistic justice, educational opportunities, and equity for these students. Our panelists will also share their experiences and insights from their local advocacy work, contributing to these conversations on advancing equity for multilingual learners. So, Dr. Kate Mencken is a distinguished professor of linguistics at Queens College of the City University of New York, CUNY. She's a co-chair of the Advocacy Committee and delegate of the New York State Association for Bilingual Education. Her research interest includes language education policies, bilingual education, and educational policies and practice for multilingual learners in the U.S. Dr. Mencken, please.
Kate, we can't hear you.
Thank you. Sorry about that. Hi, everybody. Thank you very much. I'm Kate Mencken, and the work that I'm going to be sharing now is work from the New York State Association for Bilingual Education, where I co-chair the Advocacy Committee with Tamara Alsace. These are our executive committee members, and we're a NABE state affiliate. And as an organization, we really believe in people power and that organizing works. And we actually have some good news to share on Plyler. Next slide. So just very briefly, a little timeline. Trish, you're actually there. In March of 2025, NABE was actually holding our conference the day that the English-only executive law order was passed. We held an emergency meeting in a back corner of the hotel, knowing that many of our state advocacy organizations were represented at the conference. And out of that emerged an ad hoc committee. I think some of us from an ad hoc coalition. I think there are a few coalition members maybe here. If so, drop your name and organization into the chat. But we formed the New York State Language and Education Rights Network, and it's comprised of immigrant rights groups, education organizations, language education groups, teachers union, et cetera, because you need friends, right? We need friends. And together you have so much more impact. And so, you know, the ad hoc coalition kept meeting regularly, but individually our organizations were also doing critical advocacy work in the meantime. And particularly focused, like we all came together, there's so much coming at us all at once. But we decided that what we were going to do was to focus on New York State legislation that would ensure free public education to all students, regardless of their immigration status, and also codifying language access policies. And are very, very thrilled to announce that in May 2026, our governor, Kathy Hochul, signed a sweeping package of immigration reforms into law. Next slide. So NABE is an organization. These are 3 different bills that we supported. And I just can't emphasize enough how important it is to talk to your local elected officials. I'm going to just share with you very briefly kind of what the work entailed for us and as an organization in case others want to try the same in their states. I really hear you, Mr. Science, saying that, you know, maybe Plyler is okay, but better safe than sorry. It was our feeling in New York. And we work closely with Catalina Cruz and Shelley Mayer. Catalina Cruz is a New York State Assembly member, Shelley Mayer, New York State Senator, and they devised a Plyler bill very much emulating the one that was passed in Illinois. And then there are also the New York for All Act and the Protect Our Schools Act, which also contribute significant protections for immigrant students and families. And as an organization, we decided to support and back all 3 of these and advocated for them. You can use the QR code to see them. Next slide. So this is just an example of a hands-on activity that we did with NABE members. It turns out if you go to the Senate bill, which is the one prohibiting children from being denied access to a free public education due to citizenship or immigration status, and you can click just I, where it says on the top right, are you in favor of this bill? So we worked with all of our members to just click this and do that. And next slide, please. And then we created a how-to contact sheet with a script so that you could find who your local representatives are, contact them, let them know that you support these 3 bills. And it was amazing to see what everybody did, taking it back to their local districts across New York State, and getting everyone at their school to click I on that bill. And that these things really do come together and make a difference. Advocacy works. Next slide, please. So the new immigration package, what it did was that the way that Governor Hochul was able to fast track this into legislation was by modifying existing state legislation to incorporate key protections from the 3 state bills that I mentioned previously. So incorporating Plyler protections, we now know that in the state of New York, regardless of what happens to Plyler, students will be able to receive a free public education regardless of their immigration status. And they pulled components of that bill, components of New York for All, like prohibiting law enforcement from collaborating with ICE. And then we also got the sensitive locations protections back. And that came from the Protect Our Schools Act. So, you can click the QR code if you want to read the package of reforms in greater detail. Next slide. So for us, our next steps, later this month, we're going to be meeting with Attorney General Letitia James' new Immigrant Trust Office, which was just created by the governor and charged with ensuring that Hochul's immigration package is upheld. We also surveyed our NABE membership, and we're going to continue, and the previous is with NICE Learn. And then NABE as an individual organization, we're going to continue to prioritize protecting immigrant students and families in our advocacy for 2026, 2027. And the last slide, please. Previous, yeah. Okay, so these are our takeaways as an organization. And I really just want to encourage all of you, take off your earrings, roll up your sleeves. This is the time. That local level advocacy matters. Engaging with local politicians matters. Context matters. We have the trifecta, the Democratic governor, Democratic majority in our New York State Senate, as well as in our New York State Assembly. And working in coalition, making those friends really matters. It's all of our organizations working together. Information sharing matters. We've held a series of town halls and we'll continue to do so. And hands-on collective advocacy matters. So go for it. Advocacy works. Thank you. And I'm happy to share all everything. I'll drop my information one more time in the chat.
Thank you, Dr. Mencken. Next, we will hear from Dr. Margarita Machado. Dr. Trish Margarita Machado is a professor of language and literacy at Purdue University in West Lafayette, Indiana. She also holds a courtesy appointment in the Asian American Studies program. Trish is a licensed K-12 teacher, coach, and administrator from Arizona and Indiana, where she taught and led multilingual learners, adult education, and middle and elementary school. Dr. Margarita Machado's research focuses on the intersections between language learning, gender, and race, and how this informs the identity acts of educators of bilingual students. Guided by the critical and feminist thought, she examines how these overlapping identities inform the logic of educational decisions making for bilingual students and families. Dr. Margarita Machado, please.
Hello, everybody. Welcome. Thank you so much for being here. So, Kate, thanks for that great presentation about New York. New York is a setting where we would call it a historic destination state. And now we're taking a bit of a detour to look at Indiana, which we would call a new destination state for immigrants, which means that infrastructures and thereby ideologies often informs the ways in which policies are understood, misunderstood, dismissed, omitted. And so I'm going to go into a little bit of a different direction as to what we're doing to uphold the law of the land, Plyler veto. So I'm going to be looking at this through looking at the impact of Plyler and what are some of the circuitous ways when we think about, as to Maria's point, around education being a human right, and that we have access and opportunity. If that is indeed part of the spirit of Plyler, then let's take a look at those original arguments and then how that manifests into local policies, how they are, one, implemented, understood, or misunderstood. So I want to kind of go back to the original Plyler arguments that were made by the state and the district to basically not allow undocumented students to come into school or to charge them tuition. And so some of the arguments that were made originally, prior to it making its way to the Supreme Court and the lower courts, was education is the domain of the state. And so that's the construct of decentralization. Let us do what we're going to do in our local context. Undocumented children promote illegal immigration. So we should be using not admitting them means the deterrence method. Immigrant children harm the school. Immigrant children are less likely to be vaccinated. Immigrant children are a suspect class. So we see this separate and exclude and quarantine, and then separate and exclude and evaluate for a documentable risk. And so I think it's important to keep these things in mind, because one of the things that we're saying, even though Plyler is not at risk and is the law of the land, these sorts of ideologies and ideals do perpetuate themselves in different ways. So while laws matter, ideologies often arbitrate the decisions that are made at local levels. And when I say local levels, I include the state, our state, as well as districts and communities. Next slide, please. So I'd like to point us to the EdWeek Plyler tracker. If you've not seen this, they update this pretty regularly. This was last updated on July 1st. And what you'll see here are our 50 states, and you can see all the states that introduce Plyler type oppositions, where undocumented children would not be admitted to school, would not be admitted into the school choice formula, would have to pay tuition depending on the state. And so the good news is the actions failed in 5 of those navy blue states, one of them being mine. And then the great news is this is where red is good. You can see 4 states that have enacted protections, just like New York with what Kate was talking about. And then you have new proposals in Ohio and New Jersey that are proposing things that oppose Plyler at this time. But I'm going to go into the details a little bit further here. And again, remember that new destination state, Indiana and others. So if you could click the next slide, click there, and you'll see those little arrows mean that they're a new immigrant destination state, places where immigrants are more newly settling and becoming larger diasporic communities, which is different than places like Texas, California, New York that has a longer history. So take a look there. We're a new destination state, and let's click again. And this is where I'm going to take a bit of a detour and talk about waivers to educational policy, which gets at the core of access to education and opportunity of education as a basic human right. What I see here, what you see here is the W, which stands for a waiver. And a waiver is waiving oneself away from federal requirements that often really contest the texture of the Equal Protection Clause of the 14th Amendment in the Constitution. So you can see that the states represented there, one being mine, those are also new immigrant destination states as well. And all 5 of us have received approved ESSA waivers, which provides greater flexibility for what we can do with our federal title funds. Next slide, please. So this is the approval. It was a press release from the U.S. Department of Ed upon Indiana's approval just this summer for the flexibility in ESSA accountability. And it basically allows states to consolidate approximately $50 million in federal funds over the next 4 years. And it also allows us to launch a pilot with 15% of local districts that would let them to consolidate 2 program funding sources, 2 and 4. Thankfully, this is not Title III, which is earmark funding for identified English learners. However, English learners are a part of 2 and 4. And so the state is going to be able to direct some of those dollars towards this, but only to 15% of the districts in the state. There's no specificity at this time as to what that is going to look like. And this is where advocacy matters, where we maintain that the children that we have in front of us continue to receive access and opportunity. Next slide, please. So one of the things that I want to be thinking about in terms of advocacy, because I think if Plyler is protected, the next thing we need to look at is that how does Plyler continue to offer not just mere access, because access is the premise of the Brown versus Board of Education. Everybody gets the same education. And Lao, which is not constitutional, by the way, but we use it quite a bit in our field. Lao states that you must have differentiation of treatment for identified communities that we know as identified English learners. And so this is drawn from a book chapter actually that I did on gentrification in dual language. But these are all the possible funding sources that come into school districts. And I make the distinction between population specific and program specific. Next slide, please. Population being English learners. So I want to take us forward because one of the concerns is that population-specific funding will become unlinked and will be able to be used in any way possible. So NTSOL, much like NABE, has committed to a lot of this work, and you can see some of those details there. Next slide, please. I'm moving quickly. So we have published numerous white papers, and this one on financial earmarking. The money follows the child. We have used the language of the zip code to basically ensure that earmarked dollars for English learners are not disrupted, not disturbed, and effectuate the rights that they have. Next slide, please. So financial earmarking, keep track of it. Next slide, please. So I want to give you a manifestation of how this has happened. Before the ESSA waiver and before the contestations of Plyler, work was at hand. Before, our state funding of $27 million was a grant application. Now it goes to the general fund. ELD district leaders don't know where that money's going. Programming, before, grant activities were supervised by DOE and we had assurances of federal compliance. Now the supervision of the dollars has been decentralized. Do you see how that construct is showing up again? And then accountability grant activities linked to EL access and outcomes. And now it really is diffuse and we don't know what's going on with this. So while Plyler still remains the law of the land, the concern persists that decentralization is still present and will continue to challenge who are the major benefactors of flexibilities. And I think I'll end there given time. Thank you. Happy to share any resources.
Thank you, Dr. Margarita Mullaney. Next, we'll hear from Dr. Julie Sugarman. Dr. Julie Sugarman is an Associate Director for K-12 Education Research at MPI's National Center of Immigrant Integration Policy, where she focuses on multilingual learners' education and helps stakeholders understand complex research and policy issues, improve program design, and evaluate program effectiveness. Dr. Sugarman has published analysis on topics such as federal policy, supporting immigrant background and English learners, students, school funding, federal and state data systems, and assessment and accountability. Dr. Sugarman earned a BA in Anthropology and French from Bryn Mawr College and an MA in Anthropology from the University of Virginia and a PhD in Second Language Education and Culture from University of Maryland, College Park. Dr. Sugarman, please.
Thank you so much, and thank you to the previous speakers who've really set such a wonderful table of describing the legal architecture of Plyler, some of the challenges, and how advocates are responding. I've been thinking a lot lately about the frames that we use to understand our political and education systems, and I want to use my time here to reflect a little bit on how those frames shape advocacy for multilingual learners and immigrant students. The most front of mind frame is that people in our field care deeply about the communities we serve, both the specific kids and families, as well as about the bigger issues related to the maintenance and value of language and culture. You see that in people's level of commitment to their work and how they communicate to others about their work. For example, professional development often focuses on an asset-based approach to pedagogy. This approach, which is grounded in learning research, operationalizes what we know about the importance of high expectations and building on the knowledge and skills that students bring with them. Helping teachers understand that perspective and why it's so important to multilingual learner education is a critical part of the work. But not everyone you need on your side is going to be moved by arguments about the value of language and culture. And sometimes you need people to take action, but don't have the time to help them develop new habits of mind. So educators need to build a second set of skills to be effective in persuading people in different contexts. In terms of Plyler advocacy, there are ways we can rally support using messages that resonate with people who may not be that supportive of immigration in general. We heard some of these messages from Maria earlier from the Supreme Court that said things like, we don't hold children responsible for the decisions their parents make, and education has an exceptional social importance. Those are things that people of all backgrounds can rally around. Messaging strategists tell us that one argument that plays well across the political spectrum is that the education system should be fair, so that schools level the playing field and give all students what they need to achieve. Another message that can be effective is to connect that academic achievement with long-term outcomes, tying education to helping individuals and communities thrive financially and contribute to the economy. I appreciate that a lot of educators don't love this line of argument because it ignores all the humanistic and societal benefits of education. But it works because it reframes the question from should these students be here to what does it cost us if they're not educated? A question that makes sense to almost anyone, whatever they believe about immigration. Similarly, there are practical arguments about the chaos that repealing Plyler could bring, whether having to do with what it would take for schools to identify and report the immigration status of every family that comes to enroll, or what happens with those kids day to day if they aren't allowed to be in school, as Tom Science told us earlier. All of this brings up another point about what advocacy looks like. The asset-based approach that makes so much pedagogical sense operates on a different logic from the civil rights framework that acts as a backstop against discrimination. As opposed to foregrounding students' strengths, the legal architecture of civil rights depends on being able to name what was denied to someone and how that negatively impacted them. Even if the Department of Justice is not pursuing civil rights violations with the vigor it had under previous administrations, the Civil Rights Act and the Equal Opportunities Act are still the law of the land. These laws recognize that denying a student meaningful access to instruction because of national origin is discrimination. A lawsuit grounded in that principle points to something specific that needs to change and gives schools the opportunities to do that. There's sort of a similar logic when speaking with policymakers because they respond to hearing what is broken and how they can fix it. That's part of why advocates keep the achievement gap front and center, not because they think of kids in deficit terms, but because if you tell an appropriator of dollars that English learners are doing well, they won't feel urgency to target funding to them. This brings me to my third point, which is that advocacy for multilingual and immigrant students takes a lot of different forms, and all of them matter. We might first think about some more obvious forms of advocacy, such as litigation or attending public protests. As far as Plyler goes, some of the most visible progress, which we've heard about this afternoon, has been legislative, with advocates and policymakers working together to pass measures in places like Illinois, Massachusetts, and New York that protect immigrant children's right to education and enact other safeguards such as data privacy. Beyond those types of advocacy, there are so many things that we need in this moment, and there are many ways to contribute. For example, it's really important to tell stories and document the impact of policies, which puts a human face on what might otherwise be an abstract legal question. With regard to immigration enforcement, journalists have been writing really powerful articles about how ICE is impacting education and how schools and communities are responding. I don't know if they think of those articles as advocacy, but they certainly can function that way in communities. There's also the somewhat quieter work of providing information about what has and hasn't changed in federal and local policy. Whether it's colleague to colleague or educators helping families understand their rights, English learner specialists throughout the country have been serving as trusted and accessible sources of such information, which is no small thing when misinformation moves as fast as it does. This leads me to the last thing I wanted to mention, which is that I know there's a lot of educators who feel very worried about what is going on and feel like they're facing it all alone. I think it's incredibly important for you all who, by virtue of just being on this webinar, are more hooked into the national conversation than most, to share with colleagues that there are people who are working incredibly hard on the issues that we're concerned about, even if it's not very visible. In addition to the organizations you're hearing from today and other specialized groups dedicated to the education of multilingual and immigrant students, there are numerous education equity and civil rights think tanks and advocacy organizations, professional organizations, and funder collaboratives who are devoting energy to doing important and helpful work. That includes research, convening and connecting stakeholders to each other, and disseminating information to their constituencies. There are also policymakers and their staffs, more than you would imagine there would be, who are paying attention and pushing back where they can, even when it doesn't make the news. None of this makes any single day easier in a tough environment, both in terms of the challenges to Plyler and immigration enforcement actions in communities generally. But it means that no one is starting from scratch. And I hope one of the messages you take from this webinar is that there are people, organizations, and resources ready to help. Thank you. I'll turn it back to the organizers.
Thank you, Dr. Sugarman. We want to extend our heartfelt thanks to our distinguished scholars for being with us today and for generously sharing your knowledge, experiences, and insights. Your presentations have both deepened our understanding of these important issues and inspired us to think about how we can continue to make a meaningful difference in the lives of multilingual learners. We will now transition into our Q&A portion of the webinar. Nicole, what are some of the questions from our audience?
Hi, I am going to share this question from Lisa Tabaku that says that there's always been districts that have not followed the Plyler versus Doe policy, for example, requiring social security numbers for enrollment. And therefore, in this local climate, schools could feel empowered to ignore Plyler complaints while at the same time the DOE OCR office has been weakened. What other organizations can school and district-based advocates turn to for protecting students' right to a free public K-12 education?
If I may, certainly you can turn to MALDEF. As I said, we have vigilantly protected Plyler since it was issued. And other than those state laws I mentioned previously, that generally has been a school clerk or sometimes a principal who decides to ask for a social when it's not required. And whenever that has happened, we have written to the school district. And once the higher ups are informed it's a violation of Plyler, it goes away immediately. Because it often is someone who is just acting on their own, maybe intentionally, maybe they follow anti-immigrant politics and are trying to do their part, but eventually they get overruled when the issue is brought to the attention of the proper authority, superintendent and board, by a legal organization like MALDEF, and we are happy to do that again. But it is a danger, the rhetoric, the attacks, embolden people to take it on themselves to try to engage in anti-immigrant behavior, like asking for a social security number when someone's trying to enroll a child in kindergarten when that is not required. So there are dangers from these attacks, even though, as I said, the decision itself is not in imminent danger.
Another question is, what practices should school districts be examining right now to make sure they are not indirectly undermining Plyler?
So again, if I'm allowed to speak first, lots of times people plan field trips where those still occur to places where undocumented students may not be allowed to enter. That could be some place that's close to a port. It could be some government buildings that are not open without an ID that an undocumented child might not be able to obtain. And it's these sort of extracurricular activities have always been my greatest concern with respect to Ply. There's so many extra activities that are nonetheless contributors to education are not available regardless of status. Whether that's a summer program that's operated by somebody other than the school, or under the Trump administration, now after school job training programs are not available to undocumented students when those are really a part of the education. So that's, in my view, what school districts should be looking at. Are all of the education related activities, particularly for high school students that may be looking for extracurricular activities that promote their education, are they really available to students regardless of status?
I have a few suggestions. So one thing is to have conversations. This is where I say manage up, because we always think that people will know the letter of the law. And what I usually find is that there's great ignorance. There is no preparation for administrators and teachers around Plyler. It really is reserved for people who are ESL or bilingual specialists who know about that. And those folks may or may not be present in the right circles when those sorts of decisions are made. So work with human resources, require collaboration with your local state agency, your Department of Education, all of which will have a state attendance officer. Now, I recognize that departments of education are increasingly appointed individuals. As is the case, many superintendents are no longer elected, but rather appointed by the legislature. So you have to be careful, but those are certainly mechanisms that you can use. So human resources at the local level, administrative training at the local level, and then also at the state level, your state attendance officer. And if your state attendance officer is not familiar with Plyler, it's an opportunity for teaching. So I think advocacy, we have to recognize that part of it is really teaching. And so if someone is ignorant, that means they just don't know yet. And they have the capacity to be transformed by information. That, in one way, contributed to the failure of the Plyler movement in our state, is they were unfamiliar with the Plyler case, but also they recognized that economically, some school districts would lose 30 to 40% of their teaching staff and 30 to 40% of their capital building projects. And when you state that in clear terms, that there's a recognition, it's a form of economic interest convergence that can levy decision making. It certainly doesn't necessarily impact empathy, but it can be a strategic endeavor.
Thank you so much for sharing. There's another question here. What other organizations can school and district-based advocates turn to for protecting students' rights to a free public K-12 education?
I might just add, if I could just take a second here, that in North Carolina, we've had, a lot of things have changed. We have a conservative legislature. We have a lot of money that's been put by the legislators into private school and voucher programs. And so public schools are navigating a lot of different financial and budgetary issues. Some other things that are happening are challenges to dual language immersion education programs in the state and so on. So in the past 6 months or so, I've had families, parent groups actually get together from very different backgrounds to try to advocate for educational programs for their children. and they feel that their rights and their children's rights in some cases have been violated because they haven't had access to the programs that they were promised and so on. This might be a side way of answering the question, but we've been working with the North Carolina legal aid programs that ensures educational access. They don't work specifically with immigration rights, but at the state level, there are those educational legal organizations that families are turning to when they feel their rights have been violated. So I just want to share that. Their NC Justice Center is one. They work in immigration issues in particular, but the NC Legal Aid Program has been available to families who are facing some of these questions around educational access.
I'd love to add that I think the question of which organizations to go to is so different in different states, depending on who the advocate groups are. A really good place to start is actually with your district or state English learner leaders and ask them about who are the players in the state. And even in what we call red states, there are advocacy groups working with immigrant coalitions across their states, and those folks really tend to have a lot of political power. And even if they're not specifically involved in education as an area, they often have the kind of political power where they can call attention to problems. And so, obviously we don't have the Office of Civil Rights or the Department of Justice behind us to call that kind of attention, but schools do not want negative attention of any kind. And so you really need to find who are the people that can call attention, that can just sort of do it subtly at first, and then bring the attention to the right people in order to say, we're watching you. Even if the Department of Justice isn't there, the advocates in this state, the advocates in this town are watching what you're doing, and we want to make sure that you have the resources you need, and we'll work with you to do that. But we're also keeping an eye on what you're doing and making sure that you're still following the law.
And local pressure can sometimes be more powerful than a distant federal source. So it is the power of proximity. I don't want to belittle the federal force, but local influence can arbitrate quite a bit.
So I do just want to say, I hope anyone will reach out to MALDIF if they face these issues. We do monitor this nationwide. But I would add there are not legal organizations, but the teachers' unions, both NEA and AFT, have always been very strong supporters of Plyler, in part because they recognize you take the kids out of school and teachers lose their jobs. But they are very strong on these issues, and they do their best to educate their members about the importance of Plyler when they may face local challenges.
Wonderful. There's also a question here asking, and I'm going to modify it a little bit. It's about academic scholars, but I'd like to say practitioners, teachers as well. How best can folks balance advocacy work with their teaching and research projects?
I would say that it's all combined. I mean, even me, I'm not a scholar, I'm not in any university, and specifically MPI does not do advocacy work. We don't do lobbying or anything like that. We're a nonpartisan research organization and think tank. But the work that we do is bringing forward these arguments about what's effective and what works and what laws should do, and telling policymakers, if you have this policy and you have this goal, the policy and the goal are not in concert with each other. So I think a lot of the work, as I was saying in my presentation, a lot of the work that we do that doesn't look like advocacy really is advocacy, explaining things, doing research, all the research articles that we all depend on. I saw another comment in the questions about the research. All of that research we count on in order to provide this information. So that is, a form of advocacy as well.
And just to add to that, I do think it very much depends on where you end up working, if it's seen as part of the work or if it's seen as something on the side. But I think, I don't know, I feel like I speak for most of us here that we do this because it comes from the heart. And how can we not advocate within this current moment? So even if it does mean late nights sometimes, I think we do our best to try to balance it. And getting tenure really helps.
Truth. I would just add to that. I think you don't have to do this in isolation. So if you're feeling rattled by what is happening or not happening, find your people and just start asking questions and they will emerge. And if it's just one or two, if it's just two or three of you, that can be a conversation at lunch, it can be after school, and that informality can lead to something super powerful. So don't feel like you're limited by having to go to a legal organization or a teachers union. It can be as simple as that. Also, just be really aware of your ESL or multilingual affiliates in your state. TESOL and NABE all have affiliates in almost every state. And a lot of those are becoming more and more K-12 facing. TESOLs used to just be adult facing, but they're now more K-12 facing because of the need and the demand for people to learn more. But they also oftentimes are nonprofit organizations, which allows them a reasonable level of leverage to be able to politically advocate. Like Indiana TESOL, because of its tax status, we are able to make stances and we are able to say, we oppose this, we support this, we want to participate in this. And it isn't just opposing and supporting particular policies, but we have learned, because we're in a very conservative context, you need to sit with them, sit with the people that really you think, oh my gosh, this policy is so oppositional to multilingual students, but sitting with them and learning from them, because we need to understand the logics of how policies move. So there's instruction in that engagement, even if it's really uncomfortable. But don't do it in isolation. There are people around that can support you locally and nationally.
Thank you. I'm going to ask one more question. What resources exist for practitioners who have been dismissed because of their advocacy of students other than a teachers union?
Okay, I will just say that there are just a handful of organizations that will provide legal representation to folks who are denied tenure for discriminatory reasons. That includes First Amendment issues. And you can reach out to one of those small numbers. MALDEF does a small number of these cases. Truthfully, tenure is so difficult that there is not a lot of legal representation out there aside from unions if you have one. But do reach out to the civil rights organizations to see if they might be interested in such a case. These are happening more and more under the Trump administration because of the fear of the antipathy toward equity, inclusion, and diversity. So there is a greater interest, if you will, among civil rights groups in exploring these kinds of cases.
And for those of you, if this was in reference to K through 12 educators being dismissed for their advocacy, I would say find the school board members that will listen to you, that are, one, your representatives, but also might ideologically align with your concerns.
Just to piggyback a little bit on what Trish just said, and I work in and study rural communities, as many of you know, and sometimes those spaces operate quite differently and uniquely. What I've found is sometimes families or teachers don't know who their representative is on their local school board. And when issues come to face, they come to face issues, like issues come to the fore, and they're not sure, they go and they find out. And one of the first things we figure out is who the representative was and how they voted on an issue. What is their stance on dual language immersion education? And if that representative isn't representing the people in their region, then families learn, or they learn that they have to replace them. They need to vote them out the next time they come up for a school board election. So in some cases, this is not a short-term proposition. It's a medium-term or long-term proposition. But I think when people understand how the system works and who their representatives are, and whether or not those people are really are working in their best interests and representing them, then I think they make different decisions around that. So it can be quite a lengthy process, but I think that with the challenges also come opportunities for good change.
And we have a positive example of undocumented families being able to vote in school board elections. They may not be able to vote in a general election but they're able to vote in local school board elections. San Francisco Unified passed that several years ago, and I believe LA Unified is working on that as well. Santa Ana schools in California too.
And I want to just add to that, to Dr. Cody's point, local elected officials as well. Find out what their position is on these issues. And if you don't agree with them, try to find an elected official to run for their position who does.
Thank you so much for all of the information that was shared and all the questions that were asked. I'm sorry we weren't able to get all of them.
Thank you very much to the speakers for addressing the audience's questions. Nicole, thank you very much for facilitating. I would next like to invite speakers again to share any additional ideas or examples of events, activities, or advocacy efforts that you have participated in and could inspire our audience.
Dr. Ferreira, I would just like to say one more thing, which is I think it's critical for all of you to really promote what's already been discussed, that Plyler benefits all students, because folks outside the system don't understand that. And they have these folks who don't like Plyler who are going out and saying you have to look at each child, that somehow we're giving a benefit to each of these children, when in fact, all of the kids benefit from Plyler having all of the children in the neighborhood in the school. And it's important for people with knowledge to really spread that. To me, that's the most important message, is that eliminating Plyler is a threat to everyone, not just to the kids and families who would be initially excluded from school.
Thank you. To our attendees, we invite you to get involved by committing to writing advocacy op-eds to inform the public about issues that matter to us and that may negatively affect multilingual learners, or by participating in other advocacy activities that support these students. In the chat, you will find a file with the links that support advocacy efforts. One more time, thank you to our keynote speakers, panelists, and co-sponsors for your leadership, your commitment to this work, and for inspiring all of us to continue learning, advocating, and taking action. At this point, and before we give closure to this webinar, we would like to ask attendees to complete a survey and invite you to join one or more of the bilingual education research SIG working groups and become more involved with the Center for Applied Linguistics and with NABE. We are all doing important work and we need you. Thank you to all the panelists and attendees for joining us this afternoon.